My name is Brooke Paz. I am a second-year student here at ASU Law. Welcome to Panel 3, When Free Speech and Free Markets Intersect, moderated by Judge Patrick Bumatay, U.S. Circuit Judge for the U.S. Court of Appeals for the Ninth Circuit. From the founding of the American Republic, the ideas of free speech and free markets were not seen as separate spheres. Rather, they were understood as mutually reinforcing pillars of a free society. The founders believed that liberty required both the freedom to speak and the freedom to exchange. In their view, open discourse and open commerce work together to check concentrations of power and to allow truth, innovation, and opportunity to emerge organically from the choices of free individuals. This vision was grounded in a deep skepticism of centralized authority. Political power and economic power alike were viewed as potential threats to liberty if left unchecked. The Constitution responded to that concern by protecting freedom of speech in the First Amendment while simultaneously establishing a structure of limited government that left broad room for private ordering, voluntary exchange, and the flourishing of civil society. The theory was straightforward. In a free society, ideas would compete in the marketplace just as goods and services do, and the best ones would prevail. For much of our early history, the law largely reflected that understanding. Markets were generally left to operate with relatively light federal oversight, and the First Amendment stood as a firm barrier against government attempts to control public debate, especially attempts to favor some viewpoints over others. But over time, the relationship between speech and markets began to shift. Beginning in the 20th century, particularly during the New Deal era, the federal government assumed a far larger role in regulating economic life. The rise of the administrative state brought with it new regulatory frameworks governing industries, communications, and competition. In communications law, regulators sometimes concluded that ensuring robust public discourse required government oversight of private platforms. Policies like equal time rules and the now famous fairness doctrine reflected a belief that certain media gatekeepers wielded such influence over public debate that the government could require them to provide balanced access. Those efforts were often motivated by the desire to prevent viewpoint discrimination and to preserve a healthy marketplace of ideas. But they also raised a difficult question that remains with us today. When government attempts to engineer balance in the marketplace of ideas, does it protect free speech or does it risk controlling it? That tension has only intensified in the digital age. Today, a small number of technology companies mediate a vast share of public discourse. Legislators and regulators are debating whether those platforms should be treated more like traditional market actors exercising private editorial judgment or more like essential communication infrastructure, subject to rules about neutrality, competition, and access. Questions about viewpoint discrimination, platform moderation, antitrust enforcement, and the proper role of government in digital markets now sit squarely at the intersection of the First Amendment and economic regulation. And that leads us to the central question our panel will explore today. When the principles of free speech and free markets appear to pull in different directions, how should the law reconcile them? With that, I will turn this over to our esteemed moderator and our speakers.
Thank you so much. Good morning, everyone. Thank you all for being here. I hope you are enjoying the symposium so far. This panel is about free speech and censorship. If you read any dissents lately, you will know that we clearly don't have a censorship problem in Ninth Circuit opinions. But seriously, this is going to be an interesting panel. Unlike many of the people on this stage, your generation was born well into the digital era. Now, nearly all conversations in the public sphere happen online, from social media to news platforms. And with the advent of the digital public sphere have come changes in our legal landscape. From Murphy to Net Choice to the European Union's Digital Service Act, new legal rules have brought into sharp focus the balance and risks between government regulation versus unfettered free market. I'm eager to hear how our panelists will handle some of these issues, and it's a great panel at that. First, we'll have Jonathan Scruggs, who is a senior counsel and senior vice president of litigation strategy at Alliance Defending Freedom. Our next panelist will be Bilal Sayed. He's currently of Cadwalader, Wickersham, and Taft, and was formerly the director of the Office of Policy Planning at the FTC. Third, we'll have Adam Candeub, who is currently the general counsel at the FCC, but before that, he was a professor at Michigan State. And currently is a professor at Michigan State University College of Law. And finally, we have Professor Gregg Leslie. Professor Leslie is Executive Director of ASU's First Amendment Clinic. And before that, he spent nearly 2 decades working for the Reporters Committee for Freedom of the Press. So first up, we'll have opening statements by each of our panelists. John, you want to get us started?
Yes, great. Thank you so much. I'm excited about the panel. Hopefully I have some interesting discussion. So as was noted, I work at ADF, and we are probably known for pushing back against government censorship, right? Cases like 303 Creative, Masterpiece Cake Shop, NIFLA versus Becerra. A lot of these cases are the government infringing on the editorial discretion, you could view it this way, of private businesses. A public accommodation law can be viewed as essentially an equal access law attempt by the government to regulate equal access. We take second place to no one in pushing back against government censorship. We oppose the DSA, the Digital Services Act. We are constantly suing California about their efforts to regulate political memes. We represent the Babylon Bee, for example, in one of the quote-unquote misinformation laws that California has passed recently. So we view free speech as vital and very important, but that's not the entire story, because we also we also are involved in efforts to push back against what we call private censorship, or efforts by private entities to burden free expression and religious freedom. And that could come, for example, we support debanking laws, the effort to debank someone because of their religious or political beliefs. We have a diversity business index where we rate various large companies about how well they promote free speech and free expression. We recently sued and won a lawsuit against OpenAI for their failure to give out nonprofit discounts to religious entities. That was religious discrimination under California's public accommodation law. So I think the question for us is, like, how do we square this circle, right? Are we just being inconsistent? I don't think so. So I want to kind of propose a few things how we think about this issue, starting off with why we think private censorship or private power can be something to worry about, and then offer some lines to at least consider and think about. So first on the why, I think most people get this point. Government is huge, it's very powerful, but so are private companies. It doesn't do any good if Jack Phillips, the cake designer out of Colorado, litigates for 12 years to defend his right to, express his religious beliefs in his business, and then the next day he's debanked and he has to close his business down because of his religious beliefs. And we've represented clients who have been debanked, one a religious ministry in Tennessee that led to Tennessee passing their debanking law, one of our model bills. Idaho recently passed that as well. So it should concern us, particularly when you have raised concerns of monopoly concerns, things along those lines. There's another example, the National Association of Realtors, which is a private association, passed a hate speech code, and they started to de-license pastors who are promoting their religious beliefs online. Now, that's very important because for a long time, in order to access the MLS, which is where you list your house, you had to be a member of the National Association for Realtors. So effectively, they were preventing these pastors and other religious people from expressing their religious beliefs and taking away their livelihood. I think that should concern all Americans. So that's the why. I think the why is important, but you shouldn't let the problem, the cure be worse than the problem, than the disease. So what are some lines that we think about constantly? So this is my pitch. Here's my 15-factor Justice Breyer balancing test that you should all consider. None of the factors are decisive. I will let you know when they are decisive. But these are just some lines to draw. So the first line is obvious, and since I'm first up, I'm glad I can talk about it, because it is easy, because it is the speech versus conduct line. And that we should hold fast to that line. We've been involved in numerous cases where the government comes to court and says, no, you're not involved in speech, you're involved in just conduct. You're involved in the conduct of a business transaction, you're involved in the conduct of just hosting speech, right? We have to draw that line. We think it is a viable line. The classic example that we encounter is there's a difference between websites and hamburgers, right? When it comes in that public accommodation setting, that government can regulate what we call the equal access to hamburgers, but it's different when it's about involving the creation of speech. Even right now, we're at the U.S. Supreme Court on behalf of a counselor under the theory is counseling conversation speech or is it conduct? We think that answer is easy, that when you engage in conversations, that is speech. We're hopeful to win that case at the U.S. Supreme Court. But it is an important line to draw. The government, we should be more concerned when the government is regulating speech than it was regulating conduct. And it is a viable line to draw. We have, in our cases like Masterpiece and 303, we constantly got pushback saying, no, this line is too difficult to draw, and that you'll allow widespread discrimination if you accept these free speech arguments. And we think that has always been false. So that's an easy line. Some other things to consider is how does the regulation affect the actual speaker? And this really might turn on what the private entity, the speaker, might say is doing. Are they creating speech? Are they distributing speech? Are they editing speech? Are they transmitting speech? Or are they just a conduit for speech? And the analysis can play out much differently in that. And a concrete example that we encountered was, to go back to our cake example, accept the idea that wedding cakes can be sometimes expression. We never opposed the idea of what happens if you could, someone was required to sell a cake off the shelf. We would say that you could compel that, and none of our clients ever opposed just selling an off the shelf wedding cake to someone. But the government couldn't compel them to create the website or the cake. And a lot of judges were confused by that line, and I think it actually makes total sense. And it sounds really in telecommunications law, is this idea that for the same reason you can impose a common carrier rule on a telephone company, right, for transmitting speech, but you couldn't do that on a speech creator. And what I think that is essentially a proxy for is conscience concerns. The more closely the speaker is connected to the speech and the creation of the speech, the greater level of conscience concerns that you might have. And that's exactly why, for example, you could impose a public accommodation law on a bookstore for refusing to sell books to a religious person. Again, the farther away you are from affecting the message of the speech and the creation of the speech, I think the more role the government has. Okay, so that's one factor, and that's kind of a proxy for conscience concerns. The other thing, a factor you have to consider, is essentially the effect on the marketplace. This is just the content proxy. And just like we all learn in law school, we should be more concerned when the government is regulating based on content than content-neutral reasons. And so that's why, again, to take the telephone example, the government can impose a must-carry rule on telephone companies to carry a wide variety of speech, but couldn't force the telephone company to only carry certain views, or couldn't ban the telephone company from carrying certain views, right? Because that is that interest and concern about the government reshaping the marketplace of ideas. And sometimes these two concerns don't always align, the conscience concern and the marketplace concern, and we have to be careful to think about that. For example, I don't think the government could impose a common carrier rule on Lori Smith, the website designer, even if that doesn't carry an enormous amount of concern about content manipulation. Because Lori Smith is a content creator, the conscience concerns are enormous. It's an enormous concern when the government is forcing someone to create speech and distribute it themselves personally that violates their religious views. So that's another line you have to think about. And the last one I'd point out is just the concern about mischief, right? Just because how broad the law is and how narrow it is. And the example I would use here is we support, I mentioned those debanking laws, but we would oppose, for example, a public accommodation law that included political belief in its protected class. And one reason that is because the debanking laws that we support are very narrow. They're tied to specifically financial transactions that can't be speech, or it'd be almost impossible to conceive of speech being an issue, versus we know that the concern with public accommodation laws have been broadly applied to speakers, to religious nonprofits, various other things because of how broadly a public accommodation is defined. So when you give the government that type of power, you should be concerned, and that you run into these hypos, for example, of should you force the website designer to, create a website supporting the KKK? I would certainly hope so not. But we have to be concerned about the mischief that how broad or how narrow a government law is. So that basically is essentially some lines that we think that are important, but just because the government shouldn't get me involved, that doesn't mean there are other ways to push back. And I mentioned this before, we're involved in shareholder litigation to make sure that large companies are giving information to their shareholders. We have that business index rating public companies, for example, about how well they respect free speech. And those are general market ways to push back against private censorship. So concluding really quick, hopefully, in my time frame, is free speech is vital. It's vital to human flourishing. It's so important. We should be concerned about censorship both by governments and also by private entities. But how you do that, especially in the private space, is vital, and we have to be careful how we do it. Thank you.
Perfect timing. Thank you so much. Bilal?
Okay, thank you, Judge. I'm going to add a few disclaimers before I start. First, anything I say here should not be attributed to any clients of the law firm I'm with. Second, I do want to be clear and upfront. In addition to being at a law firm, I'm also at Tech Freedom, which is a legal think tank. The think tank is funded in part, at least in part, by platforms. And finally, I am teaching antitrust here this semester, and if there are ASU students in the audience, and I know there are, I encourage you to take antitrust and rebuild the program. I also teach it for 15 years at George Mason's now Antonin Scalia Law School, and I find it interesting. I teach at both Antonin Scalia and Sandra Day O'Connor law schools. Okay, I'm going to read my remarks because I want to be kind of clear. The Trump administration antitrust leadership has argued that antitrust law can be used to prohibit big tech censorship or more neutrally described content moderation. This position is wrong. It is wrong because it ignores the First Amendment's longstanding protection for editorial discretion and ignores a line the Supreme Court has drawn between commercial regulation or antitrust law as applied to exclusionary or coordinated commercial conduct and expressive judgment. The threshold question in any matter that may raise First Amendment questions is simple. Is the government regulating speech? Speech is not limited to spoken or written words. It includes selection, curation, prioritization, and compilation, what editors have always done. So choosing what to include, what to exclude, and how to arrange third-party speech is a classic editorial function. This is why newspapers have First Amendment rights, and it is why digital platforms do too. When a platform decides which posts appear in a feed, how they are ranked, or which violate its standards, it is making an expressive judgment. The Supreme Court recognized, again in Moody, that those judgments are protected speech. This point matters for an antitrust inquiry because once content moderation is understood as speech, government action that targets it, whether labeled antitrust, consumer protection, unfair competition, or regulatory, it triggers First Amendment scrutiny. You simply cannot avoid the First Amendment by changing the statute you cite. Now, critics of large platforms look for a way around the First Amendment, arguing that even if content moderation is expressive, antitrust law is different. Antitrust is about competition, not speech. They give the example, content decisions go to quality, and firms compete on quality and innovation. This should bring content decisions within the antitrust laws. No, the First Amendment does not turn on formalism. The First Amendment does not limit itself to asking why the government is acting. It asks what the government is doing. If the effect of regulation or enforcement is to alter the content of speech or to compel a private speaker to carry views it rejects, the First Amendment applies, full stop. The government cannot, as the court has repeatedly and recently said, rejigger the expressive realm to achieve its preferred balance of ideas. And rejiggering is exactly what recent antitrust threats aimed at platform content moderation seeks to do. The quality argument is not content neutral, but goes directly to viewpoint. Such threats are not the application of neutral competition rules with incidental expressive effects. They are attempts to change whose speech is carried, what speech is offered, where it is offered, and under what standards. The court recognized in Moody that this asserted interest, improving or rebalancing the marketplace of ideas, is not a valid government interest at all. Rather, it is a paradigmatic example of impermissible viewpoint discrimination. The Supreme Court has repeatedly rejected the idea that the state may interfere with editorial discretion to reshape the marketplace of ideas. First Amendment does not allow the government to decide that some speech has been over-moderated and must therefore be restored. Antitrust law cannot be used to accomplish indirectly what the First Amendment forbids directly. The First Amendment recognizes a boundary between commercial conduct, which antitrust law may remediate after showing a violation of antitrust law, and expressive judgment, which it may not. This line is not new. It runs through significant First Amendment cases, Miami Herald, Hurley, Turner, and now Moody, and the antitrust cases, Associated Press, Lorraine Journal, and Superior Court trial lawyers. Antitrust law applies to business practices that restrain trade without dictating editorial content. That is why antitrust law could invalidate the Associated Press's bylaws that allowed members to exclude rival newspapers. Those bylaws suppressed competition between publishers and not speech judgments within a publication. There, the court invalidated bylaws excluding rival newspapers, but did not require any publisher to print unwanted material. They were explicit about that. Likewise, in Lorraine Journal, the remedy prohibited coercive conduct aimed at destroying a rival, not editorial decision-making within the newspaper itself. When conduct prohibitions cross that line, when stopping or remediating the conduct would require or force a publisher to carry speech or prohibit it from excluding speech, they collide with the First Amendment. Analogizing platforms to common carriers or cable bottlenecks fail. Platforms are not mere conduits. Their product is a compiled expressive output, a feed, a timeline, a recommendation system. That product is itself speech. Nor do platforms have the control that cable operators had in Turner and similar cases, for example, over the sole physical pathway to homes, a monopoly granted by the local government franchising rights. Notably, the must-carry requirement the Supreme Court upheld in Turner was content neutral. Critics of the large platforms sometimes accept that unilateral content moderation decisions may not be prohibited under the antitrust laws or under antitrust doctrine would be very hard to prohibit, but argue that collective moderation decisions, those that involve agreements among firms, is within the scope of antitrust prohibitions. Yes, antitrust law can prohibit concerted refusals to deal or the joint adoption of conditions upon which a firm will deal. And the Supreme Court has been clear, the presence of expression does not automatically immunize economic conduct, but neither does economic coordination strip expression of constitutional protection. That framework matters for analyzing joint content moderation decisions, and the First Amendment still applies. Motive alone does not transform coordination on expressive conduct into unlawful conduct, and some economic effect does not turn expressive conduct into commercial conduct. Claiborne Hardware and the Eighth Circuit's decision in Missouri versus National Organization for Women draw this line carefully. A boycott undertaken to express political values, even if coordinated and having an economic effect, is protected so long as it is not aimed at destroying or displacing competition. By contrast, in Superior Court trial lawyers, an FTC case, the court found a group boycott unlawful where the immediate objective was economic advantage, raising prices by restricting output, and where the expressive component was incidental. To the extent courts are forced to consider whether antitrust enforcement imposes an incidental burden on expression, the governing framework comes from United States v. O'Brien, which permits regulation of conduct with expressive elements only if the government interest is unrelated to the suppression of expression and the incidental restriction on speech is no greater than essential. Antitrust law properly condemns cartels, price fixing, and joint agreements to exclude or suppress rivals that harm competition. But coordination around expressive standards, such as content policies, brand safety norms, violence policies or the showing of violent activity, election integrity frameworks, or community guidelines, for example, is different in kind. When platforms coordinate around shared standards, they are not fixing prices or allocating markets or excluding firms without reason. They are aligning expressive judgments about what kinds of content they will associate with. Even if those judgments have economic consequences, their object is expressive. Antitrust enforcement here would be both constitutionally suspect, highly suspect, and practically futile. There is an additional issue in using the antitrust laws to police or prohibit content moderation decisions, remedies. Antitrust law is not just about liability, it is about what courts and agencies can order defendants to do. Any remedy that requires a platform to carry speech it rejects, forbids it from enforcing content standards, or conditions mergers or market participation on changes to moderation policy is a form of compelled speech. And compelled speech is constitutionally suspect regardless of the statutory framework used to impose it. Now, I recognize that courts have upheld or compelled mandatory disclosures in the commercial context upon a finding that mandatory disclosures are necessary to avoid misleading or deceiving listeners. This is not an antitrust claim, and it applies only to purely factual and uncontroversial information. The Supreme Court has never upheld a rule forcing a private publisher to include unwanted content because a regulator or enforcer believed the public needed more access to certain or specific ideas or voices, not for newspapers,
Just 30 seconds.
not for parade organizers, not for cable operators outside the narrow situation of a government-granted monopoly, and not for digital platforms. So I'll conclude, right? What antitrust law may not do, antitrust law may prohibit all sorts of conduct of platforms, but what it may not do is substitute the speech preferences of the president, the FTC chairman, or the assistant attorney general for antitrust for those of private speakers. Private firms may choose what speech to carry. They may choose what speech to reject. They may do so alone, and within the constitutional bounds of Claiborne Hardware and Superior Court trial lawyers, they may do so jointly. Content moderation is not a market failure. It is an exercise of editorial judgment that the First Amendment protects. Thank you.
Great. Thank you so much, Bilal. Professor Candeub?
Thank you so much, Judge. First, a disclaimer. I'm a law professor at Michigan State, but I'm currently serving as general counsel for the Federal Communications Commission. The views expressed here are in the context and my capacity as a law professor and do not reflect those of the Federal Communications Commission or the federal government in any way. So I'm going to start out with something unusual. I don't think it's ever been done at a Federalist Society presentation. I'm going to start out referencing Karl Marx. And he said, a specter is haunting Europe. And he was right. It wasn't communism, but actually the specter that is haunting Europe right now is the end of free speech. Under the Digital Services Act, which Judge Bumatay referenced, or its analog in England, the Online Safety Act, 12,000 people last year in England had criminal charges, were hauled into court for views they expressed on social media. And the DSA and the Online Safety Act in England, how do they do this? How do they go around censoring speech? Well, they have laws against hate speech that we don't have, but they also have a very close relationship with the platforms. There are these things called trusted flaggers, which are essentially government-approved agents that go through everybody's, yours, mine, if we lived in Europe, they would, our posts, and they flag things for the government. They're not government actors, but they essentially have to be approved by the government. And then the government says, nice Federalist Society member over there with a beard said a bad thing, off to jail. Now, there's a difference here. The difference is technological. I mean, I'm sure before the development of the internet, people were saying things that violated the hate speech laws of Europe because some of them in some countries are very expansive. It's only because we're now communicating, as panelists have pointed out, mostly on social media. And we have a market structure where most of our online comments are focused on certain platforms, a handful of them. So what we have is a market structure that works as a sieve, as a pressure point for all communication, or a huge amount of it, and very easy ways for these large firms to collude with government and shut you up, shut me up. They've shut me up. They've shut our president up. So I think that this is a real problem. And, what can we do about it? Well, actually, Texas, and again, I indulge me with one more disclaimer. Texas passed a law which actually said, look, in the state of Texas, large social media companies, if they're acting like telephone companies, they have a huge market, they're opening their platforms to anybody, their job is simply to transmit messages. Well, you can't discriminate. You can't discriminate on the basis of religion. You can't discriminate against race. You can't discriminate on the basis of sex. Oh, and you also can't discriminate on the basis of political expression. Now, this went up to the Supreme Court. We didn't really get an opinion. The opinion, I think, was accurately described by Justice Alito as dicta. And we do know from the opinion that curating news feeds is First Amendment protected. But what we don't know is the deeper question, whether or not a state can say, look, platform, you're really like a telephone company. Your job, your social media, you connect people. You know, it's like you let me talk to my mother even when I don't want to. You make me look at my college friends' kids doing various things that I'm not interested in. That's your primary job. You are a conduit of speech, and that therefore you're like any other business. We get to regulate you. We get to regulate you. Why? Well, because one, there's this very dangerous problem where we have market structure of very few companies, and you have the danger of government collusion. Now, I referenced the DSA, but what's the joke about the Europeans and Americans? The Americans innovate, and the Europeans regulate. Very good. Now, so their DSA, was that their own innovation? No. We made this, made in America. The DSA essentially codifies a system that the platforms had worked out with government to censor COVID speech, where they would have third parties, many of whom in government, many of whom in academia, I'm ashamed to say, who would go and look at speech that they didn't like, they didn't agree with, like, for instance, the current NIH director, the great American hero, Jay Bhattacharya, who would say factual things about COVID, and they would alert. And then these nonprofits would then talk to government officials, and the government officials would then have a little conversation with the platforms. Oh, it seems to me that's a problem. It seems to me we need protection against that. It seems to me that whatever the First Amendment means, it means that people should be able to have an effective right to communicate, regardless of the whims of the billionaire princes who dictate so much of our lives and which threaten essential American institutions and structures. That's, again, something that is unusual in Federalist Society meeting. Federalist societies, anything the government does is somehow, it's anathema, it's evil, it's wicked. It's, again, a reference to the initial speaker, and I forget her name. Who was she? Who introduced us? I apologize. Brooke, where are you? Hey. Is that I think these traditions about regulating, or not regulating, but putting basic standards on communications platforms don't go back to the New Deal, and I'm referencing you because you talked about the New Deal, but actually much older. They go back to the Middle Ages. They have to do with fair treatment of merchants in certain industries to all people. If you are going to be FedEx, if you're going to be a courier system, if you're going to operate a train or an airplane, you can't make decisions. I don't like you, but I like you. You can fly on my airplane, you can't. And this is not, and this can apply easily to speech, and has been. My favorite example is from the 19th century. I'm kind of 19th century guy. I'm not a great supporter of the New Deal, but in the 19th century, there were a bunch of union riots. And union attempts to unionize Western Union, which was a telegraph company. And the way reporters would get their stories out is they would write their stories out, and then where would they go to send them to get them printed? Well, they had to send them. They were often hundreds of miles away. So it's 1872. You have to get the story to your printers immediately. What are you going to do? What technology are you going to use? Are you going to use this? Thank you. Okay. I'll buy you a beer tonight. I used telegraph. And Western Union said, oh, no, we're not going to cover this. We're not going to transmit this story by this reporter. It's critical of us. Too bad. And the state said, that doesn't make sense. We can't have a democracy if if they're very powerful entities, whether they're politicians or whether they're the corporate entities that are working with them, who can censor citizens' speech. And so all of a sudden, a whole spate of state laws were passed that said, look, telegraph companies, you can't discriminate. And guess what? The Supreme Court did uphold them in U.S. v. James, unfortunately not on First Amendment grounds, but that's another story. So that's all nice. There's the argument that there's a role for ensuring that large platforms behave in a fair way to people of all perspectives. We know that this is not this is a real concern. So, for instance, Bilal said that it's protected. That the First Amendment and antitrust protects coordination around expressive standards such as content policy, brand safety norms, violence policy, election integrity frameworks, or community guidelines. Those are protected. Well, of course, there was an individual who was removed from the platform once known as Twitter, purportedly for violating their violence policy. Who was that individual? Donald J. Trump, yes. So, somehow I don't think that our laws are designed, whether they're antitrust or the First Amendment, to prevent the President of the United States to communicating with the citizenry using a dominant communications platform. I would be surprised. I don't have my Madison lapel. I don't think James Madison thought about that when he wrote the First Amendment. And whatever the First Amendment doctrine says, I don't think it can say that. And I'm done. So thank you very much.
Perfect timing. Great. Professor Leslie.
Yeah, so I'm happy to say that my disclaimer gets to be, I'm a professor, I'll say anything I want. And my boss is at the top of the stairs, so she'll defend me on that, I'm sure. But yeah, I want to talk kind of more about how these tensions play out, especially in the work that I do, in running a First Amendment clinic, where we're trying to kind of get students involved in these actions and matters. And I kind of like to start by saying, nobody's a free speech absolutist. I met one guy once who claimed to be. He was a reporter for the Baltimore Sun, and he covered the Supreme Court. And he always said he was a free speech absolutist. And one of my interns at a talk he gave when I was at a public interest group said, well, does that mean someone has a right to shoot the president if they're doing it for political reasons, for political expression? And he finally caved on that and said, well, they should be able to present that as a defense. But he didn't go further than that, and so it kind of fell apart. But nobody's an absolutist, really. I mean, there's always an issue of when you decide the principles of the First Amendment fold to the practical realities or to anything else, any other competing interest. And that becomes the big part of First Amendment litigation. We're not just looking at what statute applies and then how do we who wins. You're starting with this idea of what are the competing interests, and once you identify, once you assign them different weights, how does that affect the presumption of who wins, or how does that affect the amount of proof that has to be offered, or what level of scrutiny has to be applied to the question? So, the First Amendment wrestling is right there at the start. You're defining the terms of the debate before you try to answer who wins. And it's in effect, in a lot of ways, that's really the, is it not picking up?
We're good. I'm sorry.
Okay. That becomes the interesting fight, I think, that, everything is about setting up the tests and setting up the way we're going to discuss the issues, and then determining how the facts determine the outcome. This is obvious in in all the areas we get involved in, but the idea of social media restrictions really is kind of a big area here. It's something that affects so many cases in the First Amendment generally, and it's one that kind of keeps getting to the Supreme Court. And so it's, we haven't seen the end of it. There are obviously competing interests there. There are obvious interests in privacy, security, defined as both personal security and national security and anything in between, as well as, other market considerations. So in one funny way, it's the one big area that brings the left and the right together, because everybody wants to limit social media in some way, but they will never agree on how they want to do that. So it's always going to be a fight. There are different aims, different interests they want to protect, and different ways they want to restrict what power is at stake. Combining all those considerations really can be a recipe for disaster in a lot of ways. And so that's why we'll never get to a uniform decision on what social media regulation should mean, in a sense. But, everyone will make the argument that they're in defense of, they're defending free speech, and they mean it. But it often, especially once you get political actors involved, it comes down to, I definitely support your First Amendment right to say that, except when you cross this line, and everybody has a different idea of what that line is. It's amazing to see how something very simple about holding the government accountable can suddenly be framed by the government as a national security threat. And, this is not political. I'm not criticizing the current president. A lot of this came up in the Clinton administration. And the Wall Street Journal did a great job of fighting back against the Clinton administration. And, it kind of became partisan in that sense, but it was a very principled stand about fighting back to not let national security interests, broadly defined, poorly defined, rule the public debate. So it's an interesting area where there's always going to be a need to look for whether the government actor is acting on a pretextual basis to kind of advance their interests in the name of protecting free speech. And I think this leads kind of directly into the idea of Section 230 of the Communications Decency Act. That does kind of affect whether people who are speaking are a platform or a speaker. There's well before the internet, there was this idea of, if a newsstand sells a magazine that has something libelous in it, should the newsstand be liable for that defamatory content? And it took a common law development of a newsstand doctrine to say, no, somebody who's just the platform for distribution should not be liable. And that's kind of what we've got with Section 230, where even a platform like the New York Times, which has a lot of news coverage, has a lot of opinion that it does take responsibility for, nonetheless has a lot of open discussion that it should not be responsible for. And so the New York Times benefits from Section 230. And I think it just goes into that idea of we've got these players in social media who are taking on both roles and who need protection, who need to be seen as distributors sometimes and need to be seen as content creators at other times. And it's just always at the heart of this litigation. And back on the idea of the national security issue, I kind of did want to mention one other case where my clinic is involved, where Mark Kelly, Senator Mark Kelly, made some comments about troops not having to follow illegal orders. And, the idea, the government punished him by saying you're going to be basically demoted. And the real controversy was not whether you could say that, because of course you can say a soldier should not follow illegal or unlawful orders, but whether what the controversy was about was an unlawful order. So again, it was, I would say it was a political question, not directly affecting national security as much as the administration said it would, but it's again one of those conflicts where we've got to really look at the issue and determine exactly how much weight we're going to give to the competing interests there and decide whether that, the freedom to say something conflicts too much with the government's position that we've got to regulate in this area, and that one will be an interesting case to see how it comes out. There's a similar thing involving the Washington Post, where the administration had a search warrant and went and got a reporter's information because they said it affected national security. But again, you know, when the Wall Street Journal was in that position for years, and still often is, it's never been an issue before. You didn't search a reporter's home. In fact, there's a federal law protecting against that. You could certainly subpoena and fight over the issues, but we're kind of ignoring those rules sometime, and I think you know, we've got to stick to the idea that we've got to defend those principles.
Great, thanks so much for those wonderful opening remarks. Before we open it up to student questions, I wanted to give the panelists a chance to respond to anything they heard. John, would you like to offer any response?
You know, the only response I'd say is, you know, with all these things, the devil's in the details, right? How do you distinguish between a speaker, a creator, a transmitter, a conduit? Because that's a very weighted thing. I just go back to my original point, is that, you know, we've got to be thinking along the lines of both conscience concerns and free market concerns. It's interesting that in the history of First Amendment litigation, most of the compelled speech cases sounded at first in free exercise claims. Barnett, Woolley, and then later, obviously, 303. And those can play out differently. Again, that the idea that we have an enormous corporation, they might have a less of a conscience concern in what they're doing than the person who's creating speech individually, right? Now, that doesn't mean the corporation has no free speech rights and loses all its free speech rights, far from it. But I think you have to be thinking along both axes simultaneously when evaluating any regulation. So I'd be interested if anyone has any thoughts on that. But that was kind of the gut reaction to others' comments.
Thanks, John. Bilal?
So excuse me, I don't have a lot of comment. Although I don't want to say this as I take issue with a couple things that are said, but I actually find the framework for thinking about this First Amendment question within the context of antitrust laws quite simple. And a lot of what I heard today from the panel, I thought overstated the complexity, at least with respect to articulating, you know, when antitrust law might be appropriately used against the platforms, or let's say inappropriately used with respect to content decisions. The reason I say, I'll give you an example. I mentioned the Superior Court trial lawyers case. Now, if you haven't taken antitrust, you probably haven't heard of it, and I'll have a written version of my remarks with footnotes and all that. But the appellate court opinion in that case was written by Judge Douglas Ginsburg, a good friend of the Federalist Society and a good personal friend. And he created the Supreme Court overturned his decision. He had created a sort of a commercial conduct, but with expressive component. And maybe that would be a way to get at some of these First Amendment / antitrust questions. And that would have mucked things up, made it very hard. And the Supreme Court, I think, was very clear in saying we're looking basically at the primary rationale. We're not looking at incidental curtailment of expression or incidental economic effects. So I think, at least in the antitrust area, it's very clear how to apply the doctrine. And I'm going to say this without being critical of what Adam has said. I think a lot of what I heard from Adam was a policy argument, and that may be fine, but that's not where the law is today, I think.
Okay. Adam, I'm sure you want to respond?
Yeah, telling a law professor that his comments are policy is fighting words. I think the fundamental...
That's why I said it.
Yeah, the disagreement... Okay, let's get going. The fundamental disagreement I think I would have with Bilal is that we're talking about companies, tech companies. What is their primary product? Ads, words, exactly, words. And so they deal with, well, actually, their primary product is you. I mean, they're selling your eyeballs to their advertisers. So in a way, it's not expressive at all. I mean, there's nothing expressive about what they do. They have a purpose, and that's to essentially sell your time and get a nice commission from it. But it deals with words, so therefore, Bilal automatically assumes, oh, it's First Amendment protected, without asking the questions, does it express anything? Actions does not necessarily receive First Amendment protection. It's only conduct that is expressive. And that's a real question. What in the world do many of these platforms express, except incredible greed? I don't know. I didn't say that. But that's a fair question. What are they expressing? What is their message that is so important that they get across? That's number one. Number two, and I think we'll talk more about this in the questions, because it's a very interesting question. When a platform curates, when it edits, when it puts comments in alphabetical order or chronological order, is it expressing anything? If it is expressing anything, does those expressions receive First Amendment protection? Those are very interesting legal questions that undergird the position that Bilal is putting forth that haven't really been answered. Love to talk to you about that. They haven't been answered by the courts, and we don't really have, I think, good answers for them yet. And last, there is, and then I'll shut up, I promise, Your Honor, is that there is a problem with saying, oh, there's the steel industry, and there's the pharmaceutical industry. Oh, and then there's this big tech industry that sells ads. Antitrust applies to A, applies to B, but not to C. They're special. And in a way, it's a form of, First Amendment dirigism. We've talked about First Amendment Lochnerism, where, the expressions of corporations, exempt them from regulation. This is First Amendment dirigism. I'm sorry, I'm being pretentious. Dirigism, what is that? Anyone? Come on. It's the notion of a planned economy. It's from the French. And the idea is like, we like this industry, we like that industry, we don't like that industry. And so by giving one of the most dominant industries in the world today, namely online big tech, social media, a special First Amendment protection from antitrust, and who knows what's next, what you're saying is like, oh, you're going to get, we're singling you out for special legal protection. And I don't think that's really justifiable.
Okay, great. Professor Lossley, I'll give you a minute, Bilal, at the end.
Yeah, I just have something quick, I guess. I often, when I'm talking to my students,
Microphone. No, just put it closer.
Oh. When I'm talking to my students, I'll often get into a conversation like that, okay? Am I being too cynical to say that social media is just advertising? If you're not paying for it, you are the product. That kind of phrase. But at the same time, you could give a lecture that says social media has changed the world. And it changed the way we handle elections, and it changed the way we interact with issues. And for those of you not around before social media or the internet, it really is a fundamental shift in how knowledge is transmitted. And so there's definitely a First Amendment component in there, and there's definitely an advertising component in there. And it's not an easy resolution, but it's something that I think we do have to respect the role that the internet and social media have brought to public discourse.
Okay, Bilal, I'll give you 1 minute so we can get to student questions.
Sure. So, look, I'll say two things. Certainly, the platform companies are not immune from the antitrust laws. We've seen antitrust cases. We've seen the government win some. We've seen the plaintiffs win some. So, and second, the steel industry, the pharma industry also have First Amendment protection, right? It's just they're not generally in the business of curating content or transmitting content, and so it doesn't come up in the context it comes up with respect to platforms. But they all get First Amendment protection, and a good example is the Norr-Pennington Doctrine, right, which protects petitioning by the government for anti-competitive means by single firms or joint set of firms. So the question is this the right, the application of antitrust law, I think, doesn't fit here, at least the way I described it. And on this question of incidental or not, that was the issue in Superior Court trial lawyers, right? I mean, it was basically a group of D.C. Public defenders decided to withhold their services until the D.C. government gave them a raise, to represent indigent defendants. And the FTC treated that as a basically hardcore group boycott, effectively price fixing. The lawyers said, well, this is expressive, right? We are calling attention to the fact that the D.C. government is not paying us enough to represent indigent defendants. And the Supreme Court made very quick work of that argument, right? So courts can get this right as it is, and they are.
Great. Thank you so much. And so let's open up to student questions. We have the yellow boxes. Let's start on that side.
Who'd you point at?
Go ahead.
You should have told me that while I was all the way up there.
Go ahead.
All right. Hi, Corbin Witt, 3L at Scalia Law. I have a question primarily for Mr. Candeub, kind of inspired by our last panel. In Wyoming, there's a bill currently going through the state legislature that is meant to give a cause of action for Wyoming residents against foreign agency officials that are attempting to censor them on social media. And I want to get your take on that, state stepping in and saying, yeah, we're going to protect our residents and our businesses that are facing this foreign censorship, because you mentioned the DSA and the OSA and all that.
Well, thank you. I'm not commissioner. I'm I'm general counsel. So just for the form of it. But thank you. I like that title. So again, honestly, I'm not familiar with it. I mean, I suspect the last panel. There are federalism issues here. In that, as I remember from my con law class, states are generally discouraged by the Supreme Court from having their own foreign policy. On the other hand, I think laws like Wyoming's, like Texas's, which attempt to protect us, protect our First Amendment, our way of having political discussions, our way of life from the Europeans, they have to be protected, because given the nature of these interconnected, globalist firms, the censorship that is being done in Europe will be felt in America unless there's some legal protection.
Great. How about over here?
Thank you all for coming out today. I have two questions, but I guess
Give us your name and school, please.
Sure. My name is Al Lee, and I'm not out of law school yet. I'm about to go into law school. Here, actually. So I have two questions on opposing ends for, I guess, advocates of more free markets generally. With the FCC specifically, I was wondering to get the panel's take on the government's actions against CBS with the licenses and all that. How does and you mentioned government censorship is a very serious threat. So I was wondering to get the panel's take. And I also greatly appreciated your comment about engagement maximizing, because when you said that these platforms aren't really exercising editorial discretion, as Mr. Saeed mentioned, it's more engagement maximizing. Right-leaning people will get right-leaning comments, left-leaning people will get left-leaning posts. It's not just like a newspaper feed. So how do free speech advocates distinguish between the sort of editorial discretion that traditional newspapers had versus the engagement maximizing protocols that social media platforms put in place that then somehow creates an expressive feed that's different for each person that views the app?
Who wants to respond?
I'm happy to start maybe on this idea of engagement maximizing. And I think the way you described it was certain feeds to people on the left, certain feeds to people on the right. I mean, that sounds like content moderation to me. Most people who write things, as an example, write to sort of maximize the audience. So I don't see either a disconnect or that it's any different than what they're doing, and that is an editorial function, right? Newspapers do it all the time. I mean, newspapers have a particular perspective. Some may try to hide it. Some may not be upfront about it. Maybe it was more prevalent 100 years ago. I don't know. But engagement maximizing seems like an editorial function to me, and I think we all, well, I don't want to put words in anyone's mouth, but I think we all sort of agree that editorial decisions are First Amendment protected.
Go ahead, Adam.
Okay, so I'll answer a short question and then I'll give a slightly longer one. I feel entitled to because it's a rather controversial issue, and I will certainly defend my chairman and the FCC. As far as I think that's a very subtle and important distinction. You know, the dirty secret about the First Amendment is that the Founding Fathers really had no concept of the First Amendment as we currently understand it. They probably would not have supported it at all. And what we're doing is largely a creation of what works for our society now. That's developed over centuries. I respect it, and it's based on a tradition. But you have to justify it. And what goes on in social media, my favorite phrase is limbic capitalism. Essentially, you know, our ids are being engaged every time we go scrolling, whether it's sex, whether it's gambling, whether it's partisan political debate, whether it is, you know, 14-year-old girls worrying about what their friends, you know, whether they're invited to some friend's party or something. And that's the level of engagement. It's very close to the amygdala. It's not exactly what, you know, my favorite theorist of the First Amendment, Alexander Meiklejohn, would say is the purpose of the First Amendment is serious debate of political and social issues. And, you know, as Marshall McLuhan says, you know, the medium is the message. This is a platform that encourages, as you pointed out, attention, not debate. And I think as a society, we get to say, look, if it's so pervasive, as Professor Leslie pointed out, if it's part of our society, we have to have a say in structuring it so as to be faithful to our constitutional heritage and the structures it created. As far as recent events in the FCC, it's important to remember that the broadcast airwaves are not private property. Who do they belong to? You, yes, exactly. And for better or worse, Congress, since 1927, the Radio Act, said that, you know, the government owns it, and those who use it, broadcasters, radio and television broadcasters, have certain responsibilities, the public interest standard. And that's all that Chairman Carr is doing, is following the law. In case you remember, this has to do with some remarks that Chairman Carr made in reference to the assassination of Charlie Kirk. I'm sorry, Kirk. That was an anxiety memory thing. But you know, the Kirk assassination was probably one of the most significant political assassinations, I think, since RFK. And, you know, I was in D.C. when it happened, and there were those minutes where you didn't know whether he was alive or dead, and everyone was looking on, you know, on the internet, looking at those videos, those horrible videos. It was utterly traumatic. It was a traumatic to the nation. We're still working through it. And so when a private actor who was using the precious broadcast airwaves by government license says statements that inflame, infuriate, enrage the situation, that are false and insulting, I think that is a situation where public-minded public officials like Chairman Carr, have to say something. And that's all he did. And just telling, there are ways that that the Communications Act requires these things to be addressed. And that's really what it was about. For better or for worse, as the Supreme Court says, the First Amendment is at the lowest ebb in broadcast. It said that in Pacifica. You don't like that? I mean, we can disagree. I mean, a lot of people don't like it. Eminent people like Harold Coase didn't like it. There was a famous article about it. But go to Congress. But people shouldn't be criticized for following the law.
Anyone else want to jump in?
Yeah, I think this raises an interesting issue of the future of spectrum scarcity,
Yeah, I know.
spectrum scarcity as a justification for regulation, because it's interesting, you both mentioned that CBS said this, but then when you wanted to find out more, you went to the internet. And, broadcast as a true, beaming out on that frequency is getting more and more rare. I don't know the last time, I don't think my TV even has an antenna. I think, I've got cable. I think most people have cable or internet or some kind of Wi-Fi connection. And so, we're not really going to have that justification much longer if we still have it at all. So I think it is interesting to think about whether this is now just content regulation and maybe broadcasters, in the sense of internet transmitters, should have greater freedom.
Okay, we had a question over there, the second row.
Hi, my name is Matthew Bilal. I'm from the University of Akron, 2L. My question focuses on the public forum aspect of this, and I'm wondering if there should be a new analog sort of common law digital form where a person may speak their mind and engage in freedom of communication with other people because the public forum has moved online, and the best way to engage with people in this current modern era is to do it over the internet. And is it fair for social media companies and internet companies generally to violate the principles of free speech by banning users' speech that they don't like?
Who wants to take that?
Well, I'll give it a shot since
for it.
I'm first here. I mean, actually, those arguments have been made, right? In, I know, the Ninth Circuit, there have been various attempts to apply traditional public accommodation laws to internet companies with that type of argument, that you've created kind of, you're the modern-day public forum. So far, those arguments have been rejected, because I think a lot of it really goes back to the same point we're debating, is that, at a higher level, is the First Amendment more about speakers or listeners? In some respects, and how do you balance those things? Because if it's mostly about speakers, then it really all comes down to are the platforms exercising editorial judgment? Are they speaking, and is that protected? And if so, that's probably going to trump an attempt by the government or the listener to override that. In the same way, someone who writes a book doesn't have the right to have their book stocked in the bookstore. Right? But if you reframe it as more of a telephone company, then sure, then the listener rights are going to trump. So far, at least, the attempts to do that in the appellate system have not worked. That doesn't mean we should reconsider those things. But I think you need to take it to the higher level. It's not just about, do I have a right to access the public access? It's really about what the speaker or non-speaker is actually doing and how much interest should we imbue into that. And that's why, again, I'll make a pitch. I'm trying to get everyone on the side of cakes and websites. Like, that's my job here, right? And that's why those cases were easy, because in those situations, the speaker was clearly exercising editorial judgment and control. They were creating the speech. So when the government comes and infringes that, right, that's when you have red flags concerns the First Amendment. But when it disperses down more toward the line of transmitting or conduit activity, you have less of that concern.
Great. We have questions on this side, right in the middle.
Do you want me to throw it?
There we go. Yeah. Nice job.
Hello, it's so great to ask this question. My name is Lydia Linscott. I am a pre-law at a local community college. And before I ask this question, I'm just going to say that I don't even know my own position on this. But picking back off of the previous question, should the federal government create their own social media platform? Because it really is the public forum, it is the public square, it is where communication happens. Should we create a taxpayer-funded public forum, kind of like public broadcast or public radio, so that people can express their views? And if so, why yes or why no?
No. It kind of going to that previous question too. You know, you're tempted to see the market and think we have to regulate the market, but you know everybody gets to be a player in the market, and that's who shouldn't be regulated. And when you talk about public radio, the federal government doesn't control the voices there. It just allows for more people to have a voice. And there's been nonstop battlings over PBS and NPR and whether they're doing the right thing with the public airwaves. So I don't think any solution. I don't see what would be fixed by having any kind of federally controlled forum. They would just have to almost get into content regulation on a daily basis. That would just be a disaster, I think.
Anyone disagree with that on the panel?
I agree with you. I don't know where I stand on this. I will say, though, we have to take more seriously as a public goal to have a more elevated political discussion. We always talk about the Lincoln-Douglas debates, and if you actually read them, and I have to admit, I never finished them, but I've gotten well through them. These were debates that were held in a public area, went on for hours, and presumably a lot of people listened to them. And you can just look at letters that were written to the editor from the 1920s and 30s that demonstrated a degree of sophistication and a carefulness of thought that, let's say, you don't see on Reddit. And I take your question much broader. How can we sort of use these tools not to provide more eyeballs to advertisers, but to build a more vigorous social and political structure? And I don't know. I have some ideas. Love to talk about it later, but it's a big lift.
Well, I'll just interject. I'm a bit skeptical of the government's ability to do something like that very well. I'd also just note across currents, it would raise a lot of interesting questions, like is the government the speaker? And maybe a parallel situation is libraries. The government is engaged in editorial discretion in libraries, and there's currently an enormous debate amongst the courts. Is that government speech, or is it not? Can the government take away pornographic, obscene type literature, or can that be challenged by those receiving that information? And that's currently an open question in the courts.
I think there's, also the issue of you could have the Lincoln-Douglas debates today and very few people would show up. So what do you do about that? Do you force people to attend? Do you force people to engage in that way? That's the next question, yeah.
So I just want to make one point, and maybe I'm making in jest or people are saying things in jest. On both sides of this discussion, there's a lot of diminishing what people talk about, right? I mean, I think there may be a reason, Adam, you didn't get through the Lincoln-Douglas debates. They're long. You may not want to read all that. And, some people want to talk about different things. And choosing between what speech, is in the public interest or elevated versus what's not. I mean, why should any of us be making that decision, right? In terms of, that issue. Now, because resources are scarce, and some firms are in a commercial business. They make choices, but you know, there's only so much of the Lincoln Douglas debates I could take, and then I want to go watch, you know, Dumb and Dumber, right? And they're not the same thing, but one is not, I don't think, inherently better than the other, or the fact that you can make one or the other is positive, not negative.
Yeah, so I'm really going to take issue with that sort of all shucks libertarianism.
That's why you're here.
Yeah, exactly. It's like
I thought that's why I was
Yeah,
here.
no, that's right. It's amazing what you can get for 2 free airplane tickets. So not much. No, I'm a law professor, and I hate to say it, but I've been doing it for 25 years, and there has been a decline. And this is the decline in the ability of students to read carefully, to follow long arguments, to look at statutes very carefully and analyze each word and each comma and each prepositional phrase. And why is that? There's a lot of evidence, a lot of very sound and good evidence, that it's because of this. Because the mode of discussion has degraded our abilities to think. And you know, I often think, I have students, and well, I've heard of students who I wouldn't trust to read a statute or a contract, and they go off in the real world, and they have clients coming to them. And the clients come to them, and they have to know what the law is, because that's the way society works. People go to their lawyers, and they find out what the law is, and they conform their behavior to it. And I think that the structures of social media, of online interaction, have degraded our ability to have discussion and analyze things in laws and other things that have been very deleterious. And it isn't a matter of like, oh, I can watch Dumb and Dumber or the Lincoln Douglas debates. It's the fact that instead of learning about politics, we don't read the newspaper anymore. We quickly get it on our scrolls. And that, I think, is something that we as a society can reasonably be involved in changing.
Okay, let's have another question. Let's go back, the red tie back there.
If you catch this, you're honorary.
There we go.
Thank you all. Chris Micah, I'm a elder 1L at Notre Dame Law School, go Irish. This perhaps might be more of a economics versus values question, but many argue that Elon Musk's purchase of X was a noble act of civic virtue to allow for free speech. Nevertheless, there might be an argument that that was kind of like a pressure release valve that prevented competing platforms from competing against Twitter and others, well, with very few, to be able to have better, more tailored, free market solutions to this problem. Which argument do you think is more correct?
Anyone want to take that?
I'm not sure I heard the last part of that question. Can I just ask you to rephrase that? I mean, I heard the first part about perhaps it was a noble free speech act. What was the?
So, if by buying Twitter, there were other platforms that were rising at the time, say Trump's platform. And
Truth Social.
Yes, exactly. And they were potentially going to provide an alternate market solution to this centralized sort of funnel that we've been talking about with very few players, anti-competitive behavior in collusion with government. And so is there another argument to be made that this noble act of civic virtue in purchasing Twitter and opening free speech actually ended up undermining the market from providing other solutions, other platforms for people who wanted to speak more openly or differently, et cetera?
I mean, I'll say people could make any argument they want. I don't think we should get in the business, ask the government to be in the business, to in a sense, pick winners and losers, pick the direction of the market. Some of that is a function of, information constraints. You may not, actually, I'm pretty sure you're not going to correctly determine how the market will develop. But I don't, I don't think we should be evaluating particular acquisitions on, sort of their generic or general merits or demerits. If there are laws that are relevant to evaluating an acquisition, they ought to be applied. But thinking that Musk's purchase of Twitter and sort of reframing it or repositioning it may have had the effect of excluding entry by new entities. I mean, that's managing the market. And, I don't think I'm really an aw shucks libertarian. But when I was younger, I did read a lot of Hayek, and, I just don't think we have that information, and we ought not to expect the government, even acting beneficially, to get it right.
Anyone else want to? Okay, why don't we do one question real quick, right here in front? This will be the last questions, and we only have about 3 minutes, so.
Thank you. My name is Vikram Valame. I'm an undergraduate at Georgetown. My question is, it seems like a lot of these regulations, for example, the Texas law that applies to companies with 50 million or more users, if I recall correctly, they incidentally or maybe intentionally shape the market to smaller companies. And maybe the lack of regulation inherently favors larger companies because of economies of scale. And I think, as was just mentioned, if the medium is the message, maybe a lot of smaller platforms will have more radical, or you could say populist politics, or maybe not. And maybe larger platforms will tend to favor like the establishment or the elites more. Like that may or may not be true, but it's an example. Do you think that that's like something relevant for First Amendment purposes that we should consider or approve of or disapprove of when creating these regulations? I guess like the worry animating this is that if we regulate a lot of large media companies, then people might just flee to like Discord or Telegram. And as we've seen, those can be even more radicalizing platforms and cause like really horrific events to occur. So that's just a concern that I have. Thank you.
I mean, this is a really tough question that has been plaguing, the internet policy people for a long time. And of course, you have the overall problem that network effects seem to dominate the structure of these platforms. Bigger is better, and why? Because everyone wants to talk to more people and receive more comments, and whether that would create more public interaction and healthier public discourse as opposed to having individual platforms with specific views that can be more radical or more out of step with median political views. I'm not an economist. I don't know. But it's part of the bigger question, which is, which I think that there is a role of everybody, including government, of how do we develop platforms and internet usage that sustains our democracy, which is something which is a very complex question.
Thank you so much. That's a great last word. Let's give this panel a round of applause.